So the next topic is Rule 114, which is bail. Section 1, bail defined. Bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate surety, property bond, and cash deposit or recognizance. Section 2, Conditions of the bail. Requirements. All kinds of bail are subject to the following conditions. A. Undertaking shall be effective upon approval and unless cancelled shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to it. Letter B. The accused shall appear before the proper court whenever required by the court of these rules. Letter C. The failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such case, the trial may proceed in absentia and letter D. The bondsman shall surrender the accused to the court for the execution of the final judgment. So the original paper shall state the full name and the address of the accused, the amount of the undertaking, and the conditions herein required. Photograph passport size taken within at least 6 months showing the face, the left and the right profiles of the accused must be attached to the bail. Section 3. Release or transfer except on court order or bail. No person shall under detention by legal process shall be released or transferred except upon order of the court or when he admitted to bail. Section 4. Bail, matter of right, exception. So all person in custody shall be admitted to bail as a matter of right with sufficient sureties or release unrecognized as prescribed by law or this rule, before or after conviction by the MTC, Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit, Municipal Trial Court in cities or Municipal Circuit Trial Court, and B. Before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Section 5. Bail, when discretionary. Upon conviction by the Regional Trial Court of an offense not punishable death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of an offense from non-bailable to bailable, then the application for bail can only be filed with and resolved by the appellate court. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency under the appeal under the same bail subject to the consent of the bondsman, and if the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail, or his bail shall be cancelled upon a showing by the prosecution with the notice of the accused of the following or other similar circumstances. Letter A. That he is a recidivist, quasi-recidivist, or habitual delinquent, or has committed in the crime aggravated by the circumstances of reiteration. Letter B. That he has previously escaped from legal confinement, evaded sentence, or violated the condition of his bail without valid justification. Letter C, that he committed the offense while under probation, parole, or conditional pardon. And letter D, that the circumstances of his case indicate the probability of flight if released on bail. Or letter E, that there is undue risk that he may commit another crime during the pendency of the appeal. The appellate court may motu proprio or on motion of any party review the resolution of the regional trial court after the notice to the adverse party in either case. Section 6. Capital offense defined. A capital offense is an offense which, under the law existing at the time of its commission and of the application for admission to bail, may be punished with death. Section 7. Capital offense of an offense punishable by reclusion perpetua, not bailable. No person shall charge with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Section 8. Burden of proof in bail application. At the hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment, the prosecution has the burden of showing that evidence of guilt is strong. The evidence presented during the bail hearing shall be considered automatically reproduced at the trial, but upon motion of either party, the court may recall any witnesses for additional examination unless the latter is dead outside the Philippines or otherwise unable to testify. Section 9. Amount of bail guidelines. The judge who issued the warrant or granted application shall fix a reasonable amount of bail, considering primarily but not limited to the following factors: A. Financial ability of the accused to give bail. Letter B. Nature and circumstances of the offense. Letter C. Penalty for the offense charged. Letter D. Character and reputation of the accused. Letter E. Age and health of the accused. Letter F. Weight of the evidence against the accused. Letter G. Probability of the accused appearing at the trial. Letter H. Forfeiture of other bail. Letter I. The fact that accused was a fugitive from justice when arrested. And letter J. Pendency of other cases where the accused is on bail. Excessive bail shall not be required. Section 10. Corporate surety. Any domestic or foreign corporation licensed as a surety in accordance with the law and currently authorized to act as such may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. Section 11. Property bond. How posted. A property bond is an undertaking constituted as lien on the real property given as security for the amount of bail. Within 10 days after the approval of the bond, the accused shall cause the annotation of the lien on the certificate of title on file with the Register of Deeds if the land is registered, or if unregistered, in the registration book of the space provided therefor, in the registry of deeds for the province or city where the land lies, and on the corresponding tax declaration in the office of the provincial, city, and municipal assessor concerned. Section 12. Qualification of sureties in property bond. The qualification of sureties in property bond shall be as follows. A. Each must be a resident owner of real estate within the Philippines. B. Where there is only one surety, his real estate must be worth at least the amount of the undertaking. And letter C, if there are two or more sureties, each may justify in an amount less than that expressed in the undertaking, but the aggregate of the justified sums must be equivalent to the whole amount of bail demanded. So in all cases, every surety must be worth the amount specified in his own undertaking over and above all just debts, obligation, and properties exempt from execution. Section 13, Justification of Sureties. Every surety also shall justify by the affidavit taken before the judge that he possesses the qualification prescribed in the preceding section. He shall describe the property given as security, stating that the nature of his title, its encumbrances, the amount of bail entered into him and still the undischarged, and his other liabilities. The court may examine the sureties upon oath concerning the manner as it deemed proper. No bail shall be approved unless the surety is qualified. Section 14, Deposit of cash as bail. The accused or person acting in his behalf may deposit cash with the nearest collector or internal revenue provincial, city, or municipal treasurer the amount of bail fixed by the court, recommended by the prosecutor, investigated, or filed the case. Upon submission, the proper certificate of deposit and the written undertaking showing compliance with the requirements of Section 2 of this rule, the accused shall be discharged from custody. The money deposited shall be considered as bail and applied to the payment of fine and cost, while the excess, if any, shall be returned to the accused or to whoever made the deposit. Section 15. Recognizance. Whenever allowed by the law or these rules, the court may release a person in custody or his own recognizance or that of a responsible person. Section 15. Bail when not required. Reduce bail or recognizance. No bail shall be required when the law or these rules so provide, when a person has been custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charged. He shall be released immediately without prejudice to the continuation of the trial or the proceedings on the appeal. The accused may be sentenced is dischero, he shall be released after 30 days of preventive imprisonment. Section 17. Bail were filed. A. Bail in amount fixed may be filed with the court where the case is pending, or in the absence or unavailability of the judge thereof, with any regional trial judge, metropolitan trial judge, municipal trial judge, or municipal circuit trial judge in the province, city, or municipality. Bail may also be filed with any regional trial court of said place, or if no judge thereof is available, with any metropolitan trial court, municipal trial court, municipal circuit trial judge therein. B. When the grant of bail as a matter of discretion, or the accused seeks to be released on recognizance, the application may only be filed in the court where the case is pending, whether on preliminary investigation, trial, or on appeal. Letter C. Any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held. Section 18. Notice application to the prosecutor. In the application for bail under Section 8 of this rule, the court must give reasonable notice or the hearing to prosecute or require him to submit his recommendation. Section 19. Release on bail. The accused must be discharged upon approval of the bail to the judge with whom it was filed accordance with the Section 17 of this rule. Whenever bail is filed with a court other than where the case is pending, the judge also accepted the bail shall forward it, together with the order of release and other supporting papers, to the court where the case is pending, which may, good for reason, require different one to be filed. Section 20. Increase or reduction of bail. After the accused is admitted to bail, the court may, upon good case, increase or reduce its amount. An accused held to answer criminal charge who is released without bail upon filing the complaint or information may, at the subsequent stage of the proceeding, whenever strong appears to court, be required, given committed, amount fixed, or in lieu thereof committed to custody. Section 1. Forfeiture of bond. When the presence of the accused is required by the court or these rules, his bondsmen shall be notified to produce him before the court on a given date and time. And if the accused fails to appear in person as required, his bail shall be declared forfeited and the bondsman given 30 days within which to produce their principal and to show cause why not judgment should be rendered against them for the amount of their bail. Section 22. Cancellation of bail. Upon application of the bondsman with the due notice of the prosecutor, the bail may be cancelled upon surrender of the accused or proof of his death. Upon acquittal of the accused, dismissal of the case, or execution of the judgment of conviction. In all instances, the cancellation shall be without prejudice to any liability on the bond. Section 23. Arrest of accused out on bail. For the purpose of surrendering the accused, the bondsman may arrest him or upon a written authority endorsed by a certificate copy of the undertaking, cause him to be arrested by a police officer or any person of the suitable age and discretion. An accused released on bail may be re-arrested without necessity of a warrant if he attempt to depart from the Philippines without permission of the court where the case is pending. Section 24. No bail after final judgment. Exception. No bail shall be allowed after judgment of conviction has become final. If before such finality the accused has application, allowed temporarily liberty under, or the accused is incapable of filing one, the court may allow his release on recognizance to the custody of a responsible member of the community. And bail shall be allowed after the accused such commenced to serve sentence. Section 25. Court supervision of detainees. The court shall exercise supervision over all persons in custody for the purpose of eliminating unnecessary detention. The RTC shall conduct monthly personal inspection of provincial, city, and municipal jails and their prisoners within their respective jurisdiction. Section 26. Bail not barred. Objection on illegal arrest, lack, or irregular preliminary investigation. Application bail shall not be bar accused from challenging the validity of his arrest or legality of the warrant issued therefor. Irregularity or questioning the absence of a preliminary investigation of the charge against him, provided that he raises them before entering his plea, as a matter as early practicable, but not later than the start of the trial of the case.